Okay, so sorry for the apologies. I think just before we had to go and come back, somebody had asked a question about discharge that we're explaining, and I was talking about the discharge by breach, and I explained that by discharge by breach, we also have what we call the anticipatory breach. I explained anticipatory breach to mean where a person who is supposed to perform obligation has actually conveys an intention not to perform on the scheduled date. Where that is the law is that the innocent party, that is the other party who is supposed to benefit from the performance, who is supposed to benefit from the performance may actually, just a minute, please. Yeah, sorry. I had a family call. Yeah, so where there has been an anticipatory breach like that, the innocent party, that's the party who's supposed to benefit from it, can decide to do one of two things. Either disregard the intention to not perform, which the other party has actually made known, actual date for performance. On the other hand, he may decide to take that serious and sue. However, where he decides to disregard the anticipatory breach and wait for the actual date for performance, between the anticipatory breach and the actual date for performance, if anything happens which can actually frustrate the contract, it will be to the advantage of the person who made the anticipatory breach, so that the innocent party will no longer be able to sue the one who had made anticipatory breach, because, as you know, when frustration occurs, it discharges both parties from the obligation under the contract. So despite the fact that this party had actually evinced an intention not to perform, he will still not be liable for breach because of the frustration which has occurred subsequent to the anticipatory breach. So let us keep that in mind. And I think another form of discharge is also by performance. So discharge by performance simply means that the parties have performed the obligations under the contract. Of course, if that were to be the case, there'll be no problem, but that is not really it. What happens is that when can we say that a person has performed his obligation, and for that matter, from the contract, where you have, originally, the rule used to be very strict. So we used to have what they call like the precision rule, right? Which is a very strict rule, which says that you have to carry out exactly what was agreed under the contract. no more or no less. But that was, as you remember from the case law, was quite harsh. So exceptions, develop that where you have not carried out strictly all the terms, but you have substantially performed your obligation, then the substantial performance would actually be regarded as having discharged you. And also where you've not strictly performed, but the contract is divisible, so that each aspect of the obligations can be can stand on their own, independent of the rest. Then if you have performed a part of the obligation which can stand on its own, you will be deemed to have been discharged by performance in respect of that. But as I said, that applies to divisible or severable contracts. So let us keep that in mind. On the other hand, where there has been prevention of performance, as remember in the famous case of the Coburn and Blanche about the book writing case, where there has been that, then because you want to perform and the other party has prevented you from performing, the prevention will serve as a ground for discharge by performance. So let us keep that in mind. Then we also have discharge by agreements. That is innovation, for example. That is where you enter into new agreements in order to end an existing agreement. So that one is also possible. So you have an agreement in force. You can decide to enter into fresh agreement, which will replace the existing agreement. And for that matter, the old agreement will be deemed to have been terminated. Yes. Any other question you can, or issues? You can use the mic. Yes. Are we together?
We are together.
But you cannot speak. I don't want your friends to know what you have in your head.
My Lord, there was a question about the difference between, like, to explain conversion and dating. I think I saw something like that before you went off.
All right. As you know, both are thoughts, and it relates to interference with someone's property. So with respect to detinum, it actually arises where your chattel or your article is with someone, you demand for it, and let's say the person refuses, a detinum action will have actually been constituted. So typically, two situations: the defendant, that is a person having the item, has actual possession of the item or the chattel, and maybe such as anything, any movables, right? Any movable, or the defendant was in the possession of the plaintiff's chattel under bailment. You remember bailment. So bailment is where you have entrusted your property or your goods to the care of another person called Bele for a period or for a period until you actually demand it. So where it was underbailment and you have demanded it, you've asked for it to be restored to you, and then the Bele refuses to hand it to you, that will actually give rise to debting. So those are some of the, so the essential thing is that you must make a demand, you must ask for return of your chattel, and then it is refused. And of course, where that has occurred, you have suffered a loss, and the loss would, for example, include loss of use, apart from any diminution in the value of the item, which was the subject matter of debting. But to conversion, as you remember, the criminal offense of stealing. That is, if you like, its version in the civil law, the third law, where someone has actually dealt with goods in circumstances which seriously interferes with the right of the true owner to the use or control of the goods. So someone has the ownership or title to the particular item or goods, and another person puts up a conduct in relation to that particular item or goods, which is not consistent with the ownership rights of the true owner, or the person having, if you like, even if you don't have like the ownership, but you have, for the time being, you have like the right to it. That will bring about the thought of conversion. So you're actually depriving the owner of possession, and someone's property has actually come to you. You have received someone's property, and you have also convinced an intention to hold on to it, not to return or surrender possession to the right owner. Or let's say that in deal with someone's property, that will also give rise to conversion. So as you notice, in the case of that, someone's property is in your possession, a demand is made, you have refused to surrender it. But in the case of conversion, not that you have just, yes, someone's property, you've either held on to someone's property or someone's items, or you've even probably caused some injury to it, because that is also interfering with the person's ownership right, because you don't have the person's permission to deal with it the way that you dealt with it, and that would also give rise to conversion. Somebody say what? Somebody has put a question in the chat. Can you read it for us?
Okay, good evening. So the question is, The provision of the Constitution of Ghana have effectively rendered coup d'etat impossible by discouraging anyone from thinking of staging one. Is this statement accurate? With the aid of relevant authorities, examine the provisions against coup d'etat contained in the 1992 Constitution of Ghana.
Okay, thank you. So those who have, I think, played the last two sessions of our online meeting, I think we've discussed this question before, but yeah, so we have a full discussion on it. But just to reiterate, if you have no question along this line, as we have said, you have to understand exactly what the question is asking you to do. So, among other things, the question is saying that, is it true that the Constitution has provisions which discourage the making of coup d'etat? So that is part of the question. And so we need to know, if actually we've discussed this time and again. I think that was even yesterday. So if you go to yesterday, I referred you to Article 3 of the Constitution, and then I referred you to an article by Lydia Nkansa, Professor Lydia Nkansa, and on the platforms I shared it. Then we also look at the cases, and then the Pianim case was mentioned. And in relation to this discussion too, I think someone also brought the effect of coup d'etats on the pre-existing constitutional order. So they mentioned like the Case-Knight theory. We talk about it, and then we also talk about the case of Salah as Attorney General. And then we actually also made the point that if you look at Article 3, Article 3 is framed in such a way that our jurisprudence, our constitution does not recognize anything called the theory of discontinuity. That is the ground norm argument of Kelsen, that where there's a coup d'etat or there's a revolution and it's successful, then a new ground norm is born, and subsequent to that, all legal norms within the legal order will derive their validity from the new ground norm and so on. We said that if you look at Article 3 of the Constitution, to the extent that it even encourages people to resist any attempt to overthrow the constitutional order, and says that where you even suffers injuries and all that, and the constitutional is subsequently restored, the Supreme Court is supposed to even make recommendation for award of compensation to you and so on. And someone brought up the question as to whether the person referred to in Article 3 is referable to only Ghanaians. And we actually had to engage in some debate that if we look at the interpretations the Supreme Court has given to a person in Article 2 to mean a citizen, be it a natural person or juristic person, then the temptation or there's a strong interpretation principle of presumption of consistency and so on, that if in the same enactment you have given interpretation to a particular word, then that interpretation should also apply across the entire enactment anytime we see that particular word. So that being the case, one will say that the person used in the Article 3, I think clause 4, 5, should be only Ghanaians. But then we said that if we take the purposive interpretation approach, then if the framers of the Constitution are actually interested in preserving the constitutional order against any coup d'etat revolution, it doesn't matter whether Ghanaians or non-Ghanaians are those who are successful in trying to drive out those who sought to disturb the constitutional order and restore the original constitutional order. Yeah, so we talked about these things yesterday. You can, if you want some detail, you can play it back on the link I sent you on the YouTube yesterday. Somebody has also asked a question. Difference between allodial title holder and beneficiary interest holder. You know, if you look at the Land Act, we have various types of interests which may be held, you know, in land. So the allodial title is the supreme, or if you like, the highest interest, which may be held in land, of course, alongside with the, you know, the freehold, except that the allodial title is the highest interest, which may be held in land as customary law. Okay, and then the freehold is also the highest interest, which will be held in land at common law, if you like. And all these have been given statutory backing. And as you know, if we look at our customary law and the cases and the Land Act, the cases of human energy and all that, you know how the allodial title is acquired, and that usually by stew or family, you know, through conquest, settlement, occupation, and so on. And we know that members of the stew or the family that has an allodial title, they are entitled to also enjoy the land in respect of which the allodial title is held, and where they enjoy that, we call that the usufructuary interest. Usufructuary interest, or what they call it, the customary freehold. Now, we used to have the two concepts, customary freehold and usufructuary interest. If you look at the literature, it used to be used interchangeably. But I think if you look at the Land Act, I don't have my Act 1036 with me here. I think if you look at the Land Act, you notice that in the listing of the interest in land, the usufructuary interest is actually listed, and then the customary freehold is also listed. Now, the person is also asking about the beneficial interest holder. Beneficial interest holder is the person who is supposed to enjoy the particular interest in respect of which, like, a title is what is held. And so, for example, when it comes to, let's say, trusts, when it comes to, let's say, like the trusts, for example, you have like the trustee, you have like the beneficiary. So the legal ownership is vested in the trustee, but the those who actually enjoy it are the beneficiaries. So they have like the beneficial interest in that property in respect of which the trust is actually created. What else? Yes, any other? Are you full of ideas that you don't want to open your mouth so that how to have learned to evaporate? Is that the case?
Hello, sir. Hello, Doc.
Yes, yes, please.
Please, I want to what rights accrue to the customary freehold interest and common law freehold interest? What are the rights that accrue to them?
You mean the incidents, or is that the
Yes,
case?
yes.
Okay. So is that the customary, say the question, customary?
The common law freehold,
Okay.
and then the customary law freehold.
Freehold. Okay.
Yes, Doc.
Okay, all right. So if you look at the Land Act, I've just succeeded in getting my version. But if you look at the Land Act, Section 4, and then Section 3 deals with the customary law freehold, and then Section 4 deals with the common law freehold. So first, as the name suggests, customary law freehold, it is an interest which is created at customary law, and it is the highest interest, subject only to the allodia, if you like, right? Subject only to the allodia. So apart from the allodia, the next highest interest is the customary law freehold. So that is why Section 3 will say that it is an interest which is absolute, which is not subject to any proprietary obligation, but subject to jurisdictional and cultural rights of the sue or the skin of the family which holds the allodia title. So the customary law freehold will be carved out of the allodia. And as you know, for those who belong to the family, okay, so those who belong to the family or the sue, which holds the allodia, automatically they're entitled to enjoy the land. And where they enjoy the land, in respect of where the allodia is held, they're exercising their statutory interest. So there's no problem. And being subject of the sue, being subject of the family, if there is war or if there is anything, as original members, indigents, they will perform their customary services and all that. But it is also possible for someone who does not belong to the stool or the family, which holds the allodia, to also benefit from the land in respect of which the allodia is held. And that will be done in a transaction. And through normal transaction, they can carve out a land for him, and the person will get the customary law freehold. Now, because the customary law freehold is carved out of the allodia, and you know that if you are a member of the stool or the family in which the allodia is held, if you exercise your statutory interest, you'll be entitled, you have to definitely contribute to the cultural rights and other obligations which you have to render to the stew or to the family, which was the allodia title. In the same vein, if you are not a member of the stew, right? You are not a member of the stew or the family, and through just transactional arrangements, we give you part of the land in respect of which the allodia is held. Yes, in respect of which the allodia is held. In respect of which the allodia is held, you have to also perform the necessary rights, customary obligations, which are due to the allodia. So that is one thing that you should note. And because it's an like absolute interest, subject only to the allodia, and also you observing the obligations which you owe the stew by reason of the land which have been carved out of the allodia. You can also do anything. It has a perpetual duration. That is to say that even if you die, it can pass on to your family or people that you may want to actually designate as being the beneficiaries, subject to the fact that they also continue to perform the necessary cultural rights or obligation which are associated with that. So it's perpetual in duration, it's alienable. You can give it to another person, it can be alienated. It's inheritable, and you don't need consent of the stew or the skin or the clan or the family in which the allodia is held. But if you look at our law, the Constitution, and for that matter, given effect by Section 3.2, customary law freehold cannot be held by Ghanaians. So a non-citizen, a non-Ghanaian cannot actually have customary law freehold. But common law freehold, on the other hand, as Section 4 of the Land Act 2020 at 1036 makes it clear, arises from a transaction to which the rules of common law are applicable. So, unlike customary law freehold, which is a customary law transaction, common law freehold can be acquired by both a citizen and a non-citizen as it will. But the customary law freehold can be acquired by only a citizen of Ghana. So let us keep that in mind. In terms of duration, just like the customary law freehold, a common law freehold has also perpetual duration, as it were. And again, the common law freehold is also subject to interest of the state, and then the jurisdictional and cultural rights of the stew or the skin or clan or family, which holds the allodia title. So, just like the customary law freehold, in which the particular stew or the clan, which holds the allodia title, can actually exercise against the customary law freehold, freehold. In the same vein, it can also be exercised against the common law freeholder, especially if the common law freehold was carved out of a land in respect of which allodia title is held. Again, we have to remember that if it's also inheritable, alienable, just like the customary law freehold. And again, if you look at the Section 4.3, since 22nd August 1969, there has been proscription or prohibition of creating customary law freehold in respect of stew and skin land. So meaning that common law freehold can apply to stew land clan land, family land, up to or before 22nd August 1969. But from 22nd August 1969 following, it is not lawful. It is not consistent with the Constitution for a common law freehold to be created in respect of a land, in respect of which allodia is held. So let us keep that in mind. But if you take two things out, one will argue that common law freehold and customary law freehold are basically the same. The rare differences being that customary law freehold actually emanates from a transaction under customary law, and then it is only citizens of Ghana that can actually have a customary law freehold. But then, if you take a common law freehold, it arises from any transaction under common law, which is like normal contracts and so on. Again, common law freehold, after 22nd August 1969, cannot be held in respect of a land relating to stool or skin. So let us keep that in mind. Okay, so next question. Somebody said, what is the question? Presumption of joint ownership of property acquired for value under the New Land Act. How does that affect position of the law to presumption of advancement? No, but if we look at our law, and then it's rather the reverse. You have the presumption of what do you call it, the tenancy in common, isn't it? Rather than presumption of the joint tenancy, because you know that or you are speaking in respect of the spousal property, right? The questioner, can you clarify your question? If you're online, yeah, you can speak. You can clarify your question. Okay, if it's not clarifying, then let me just explain it as I understand it. Yeah, so we have the two main tenancies, the joint tenancy and then the tenancy in common. You know that the joint tenancy has this use accrescendi, which means that there's no right of vote, survivorship. And for that matter, if you have two or more people holding property under joint tenancy arrangement, what it means is that if one person dies, his interests cannot be inherited by those who are supposed to inherit him and so on. It will be added on to the remaining tenants. And eventually, the remaining person will become like, if you like, the sole owner of the entire property. But tenancy in common is different. There's yes. Dominic, your hand is up.
Yeah, sorry, I was in a noisy place, looking for a much more convenient place to clarify. Please, my question is actually with respect to the presumption of advancement, where a man gives the registered property in the name of the wife. It's presumed that it's a gift, unless a contrary evidence comes to show that it's not. But with respect to the New Land Act, I've seen that where the property is acquired during the subsistence of the marriage for valuable consideration, it's presumed that it's jointly acquired between the woman and the wife. So I was trying to actually see how that will still affect that principle in terms of
Yes.
the presumption of advancement, whether there will be a shift or it might still be the same thing.
Okay. Yeah. So if you look at the thank you for the question. If you look at the land that they're trying to get a specific provision for this presumption of joint ownership for property acquired during subsistence of the marriage. In section conveyance, no, that's 37.
47.
47 years.
47.
47. Okay. So just a minute. Okay. Yeah, so 47. Except in absence of a written agreement to the contrary by spouses in a marriage, a spouse shall not, in respect of land, right or interest in land acquired for valuable consideration during the marriage, sell, exchange, transfer, or lease the land, enter into contract for sale or give away the land, or enter into transaction without the written consent of the other spouse, which consent shall not be unreasonably withheld. Yes. Yeah. So with this position, if the property was acquired, let's say in the name of a particular spouse, so let's say that the man acquired it. Okay, is that the man acquired it in the name of the woman, and for that matter, by reason of the presumption of advancement, it is assumed that it was meant to be for the woman. And how does that affect the current position that during the substance of the marriage, all properties acquired are presumed to be jointly owned by the couple? And for that matter, if you are going to do conveyance or transfer, the other couple must consent. Otherwise, the conveyance or the transfer will not be valid in law. Okay. Now, as you've rightly said, that principle, of course, we need a case law in respect of section 47 vis-a-vis the well-known principle of advancement. Otherwise, the position of the law would be that where there's a clear evidence that, just as we look at the decision of the Supreme Court in the Mensa and Mensa, Fin and Fin, those type of jurisprudence that yes, properties acquired during the substance of the marriage are presumed to be jointly owned by the couple. So that is presumption. So there can be evidence which will rebut that despite the fact that this property was acquired during subsistence of marriage, for this reason, it does not belong to the two spouses. And just as maybe the man acquired the property and used the name of the woman, and let's say that on the face of the document, it is so clear. But as I said, this still needs to be tested by a case law. It needs to be tested by case law, so we can reasonably speculate around it that since the jurisprudence from Mensa and Mensa in relation to Article 22 of the Constitution has come to be understood that, yes, there's a presumption that all properties acquired during the subsistence of the marriage are deemed to be the joint property of the spouses. That presumption can be rebutted. For example, where there's evidence that one acquired it as a result of inheritance during the subsistence of the marriage, if maybe your father or your mother died and something was willed to you, that is different thing from where you use your own money to buy a property, in which case we can say that that was really acquired during the subsistence of the marriage. Yes, questioner, that's Dominic.
Yes, sir.
Yes.
Yes, sir. Thank you, sir.
Yeah, Doc.
Yes.
You've explained, but I was actually also having the same problem as Dominic. So if
Okay.
you look at the Land Act, there are so many sections in support of what Dominic's position.
Okay.
38, section 38, section 97.5,
Okay.
97.4, all of them are in support of that position. There are some of the, even if you go without the knowledge of the other spouse, and you go
Yes.
and do anything with
Yes.
respect to the land acquired,
Yes.
you are presumed to be doing on behalf of the other spouse.
Yes.
Even when it comes to issuance of the certificate,
Yes.
if you do minus the other person, it's presumed that you have done it on behalf. So there are a number of sections there that are in support. And I want to believe that that run contrary to the principle of advancement, as put across by my friend Dominic.
Okay.
So really, I find it difficult. Really, it was bothering me, but it still doesn't seem clear to me. But as you said, we need a case law to test it or something. Thank you.
Yes. All right. What time is your paper?
10.
Okay. The rent bill, has it been passed? Or just still the Act 220 we still have? Has the rent bill been passed? Politicians among us. Or still the old one we have? You know, the parliament was close to passing it, but I don't know whether they've actually passed it. Okay, so since I have no information as to whether the new rent bill has been passed, someone has asked the question, Recovery of Possession under Rent Act. Presumably what we have is the old legislation, Rent Act of 1963, Act 220. You have to look at section 17. Section 17 addresses recovery of possession. And if we look at the section 17, before possession can be recovered, or there can be indebtment, among other things, it must be shown that rent lawfully due from the tenant has not been paid or tendered within 1 month after the date on which it became lawfully due. So where you are supposed to pay rent and you have defaulted and 1 month has actually elapsed, that can be a ground for being ejected from the premises. And 2, where an obligation of the tenancy, other than that specified in paragraph 8, that is any other obligation apart from rent, so far as that obligation consistent with this act has been broken or not performed. So if you breach any other obligation, now if I say any other, so rent is a special obligation. So that's the consideration for the landlord-tenancy agreement. So that is why it stands out. So as for that one, if you do not pay rent and have 1 month elapses, that one is a good ground for your judgment. But again, if you put the non-payment of rent aside, and if it is demonstrated that you've breached any other covenant or any other obligation in the tenancy agreement, that can also be a ground for ejectment. And then 3, where the person or the tenant residing with the tenant has been guilty of misconduct, which is a nuisance or annoyance to adjoining occupiers. So that can also be a ground for ejectment or possession being recovered from you. And then 4, where the tenant or the person residing with the tenant has been convicted of using the premises or allowing the premises to be used for an immoral or illegal purpose. So maybe they're using the premises as a brothel or as a place for smoking, narcotics, or so on. That can be a ground for ejectment. And 5, where the tenant has given notice of intention to quit. No, I don't know. Where the condition of the premise, as in the opinion of the rent magistrate or judge, deteriorated owing to acts of waste by or the neglect or default of the tenant or a person residing with the tenant. So if you are causing waste, and you are letting the property be in disrepair and so on, you don't care, that could also be a ground for ejectment. And then where the tenant has given notice of intention to quit in writing, and in consequence of the notice, the landlord has contracted to sell or to let the premises or has taken any step as a result of which the tenant would, in the opinion of the rent magistrate, be seriously prejudiced if the tenant could not obtain possession. So here, you have told the landlord that you intend to quit. And in reliance upon that, the landlord or the landlady takes certain steps in anticipation that by a certain date, you are going to be out of the premises. So where that is the case, that will be a good ground for you to be ejected from the premises. And of course, even here, Section 26 of the Evidence Act will also come in to help the landlord. That is estoppel by what? By conduct. Because you yourself have actually given notice, or you'll be giving notice that you should leave. Or where the premises are reasonably required by the landlord for personal occupation as a dwelling house, or a member of the family of the landlord, or a person in whole-time employment of the landlord needs the property, or the property, for example, is needed to give accommodation to someone who is also working for the the landlord, it can be recovered from the tenant as it were. Again, where the lease has expired and the premises are reasonably required by the landlord, reused by the landlord or for the landlord's own businesses, that can also lead to ejectment, or the possession may be recovered as it were. However, there are certain safeguards which protects the tenant. So therefore, all the things that we have discussed as being grounds for which ejectment may be ordered, they do not apply except where the lease has expired and the tenant is a statutory tenant, and the landlord intends to pull down the premises and construct new premises. So you know who a statutory tenant is. A statutory tenant, the tenancy has expired, or he ought to have actually be out, but he's there because the court or the law says that it should remain in possession, and for that reason, is protected by the law until some other orders are made. So look at section 17. I mean, section 17 will be enough for you to discuss questions relating to recovery of possession. And of course, section 18, where the tenant is given the opportunity to either engage in a new tenancy of the remodeled premises, especially where you have told the court that you need to remodel the premises, and for that reason, possession should be recovered under section 17, and then the premises are actually vacated. And where that is the case, the statutory tenant shall be entitled to the right to get a new tenancy in respect of the premises which has been remodeled or which has been improved as it will. Yeah, so look at that. Okay, so there seem to be no other issues. So I would like to wish you very well and sleep enough, get refreshed, get to the exam center early, and then just quit up with conduct, meaning that you don't attempt to help anybody in the exams room, just help yourself and plan your answers well. Say a short prayer before you start your paper. And I wish you well. Good luck to all of you.
God bless you. Thank you very much, my Lord.